Hello everybody, welcome to another webinar of the Mercosur IPR SME Help Desk. My name is Cesar Elvira, IP expert of the Mercosur IPR Desk, and I'll be your moderator in today's webinar, IP Key Aspects in Trade Fairs in Brazil. But before starting with this presentation, let me introduce briefly our speakers, Mr. Enrique Fontes and Mr. Cristiano Carvalho. Good morning, everyone. Mr. Enrique Fontes is a lawyer specialized in EU law. He has been responsible for legal affairs at Feria Internacional de Valencia in Spain from 1990 to 2011. Currently, he is legal advisor in the industry of exhibition, and he is also a member of the arbitration court of the Chamber of Commerce. Welcome, Enrique. We are glad to have you here. And Mr. Carvalho Leao is a patent attorney specialized in IP law. He was manager for Latin America at Unilever from 2000 to April 2014, after working at Johnson & Johnson. Currently, he practice focused on patent litigations and patent strategy. Welcome, Cristiano. Thank you for joining us. Well, I'd like it to be interactive. So, if you have doubt or want to know more about some aspects, please do not hesitate to our expert. Questions may be addressed to them at any time, both in English, Spanish, Portuguese, and French, for which you only have to raise your hand by clicking on the icon located top bar next in audio icons. Your micro will be then activated and you'll be able to make. Alternatively, you can write it down in the general chat and it will
Cesar, good to Brazil and good afternoon to Europe. First of all, I want to say thank you to the city of Alicante and to the Mercosur help desk program and commission for having invited me to give this talk about IPR and its in trade fairs. As the title of the talk suggests, it is going to be a very practical talk, and I hope that it's going to be profitable and helpful. But maybe the first question we have to answer is what is special with the serve a special space aside in the general topic of the IPR protection. And at this regard, would like to remind that according to experts in marketing, trade fairs are commercial of extreme value for SMEs because trade fairs provide SMEs with several things they can't offer themselves. First, fairs produce extraordinary amplification effect of the exhibitors' offers. And second, trade fairs provide exhibitors with accurate information about competitors and consumer trends as well. So in trade fairs, manufacturers and other, I'm going to look at the the image. So in trade fairs, manufacturers and other agents that take part in trade fairs, like for example, traders, consumers, associations, prescriptors, or specialized media, do not only they also exchange information that goes from one to another, and where the recipient of is stimulated by this information, and that leads him to generate a feedback that makes the will to be continuously, and that is the result of and the result of all the exchange of information is that trade fairs become a real form for innovation. And we can see also that we can say that that is the origin of the relationship between trade fairs and intellectual property. Visitors or buyers, as you want, are attracted because they look forward to finding novelties in them. And then for exhibitors, the recipe for success is to present novelties. In exchange of a reasonable investment, exhibitors obtain a multiplying commercial effect. Not all companies participate in big and powerful organizations have their own commercial channels. But in the case of the European Union, we see that there are around 27 million of registered companies. And into statistics, 99% of them are small and medium enterprises. That is why we can say that SMEs are the backbone of the European economy. And in words of the European Commission, SME, the engine of the economy in Europe. European Commission states that SMEs of the economy. I think we can exaggerating that trade fairs are the fuel that boost this engine. We can say also that Commission's words are not only words; these words are supported with facts. And in a time when industries are and where fortunately competition rules are so rigorous, state aids are also mostly forbidden. In spite of all that, the Commission has decided to include aids to participate in international fairs, general block exemption regulation, because the Commission consider or has considered that the benefits that trade fairs provide to SMEs and to the general is much bigger and important than the possible distortion of competition rules that these aids could produce. Here we have some indications what we are saying. Trade fairs are a very useful tool for SMEs. Increase sales via target audience, provide accurate information about competitors, allow to detect market trends, and boost brands building. And here we have some data, some very interesting data that allow us to identify Brazil as an unavoidable commercial partner, as an economic and industrial leader in Latin America. And also here we have some among the most important in the we have Alimentaria Brazil that by the organized by Fira House Gift by Fiera Milano, Bio Beats is Deutsche Messe Hanover Trade Fair, and after this, if we go to the point that company decides to participate in a trade fair, usually has identified its interest and its asset, and the follow in a trade is to protect assets, and in particular IPR assets, because IPR are the cornerstone for any in any industry. Example, we think of trademarks, them point of view of consumers. Trademarks play play an important to protect consumers since allow them to know which company manufactures a particular good. And few of companies, the trademarks allow them to distinguish its goods from of a competitor. If instead of trademarks we talk about designs, patents, or utility models, they provide consumers with guarantees about the originality of the product and provide manufacturers with exclusive rights to use these designs or patents. And in any case, IPR titles stimulates investments and innovation since procure protection to its holders. Since we have mentioned titles, now is a good moment to give some tips about them when we are prepared to participate trade fair. With respect to design, patents and utility models, I must remind that it is required its character to register them. If the design or the invention has disclosed to the public, it lacks required novelty character, and then the application to register the title will be rejected. And when post is considered that the product is available to the public, so the registration could impossible, but I will this information all this. But we recommend that before participating in a trade fair, it is advisable to register these patents. But nevertheless, as I have said, this must be nuanced because in some industries, such as, for example, interior design and also tile coverings, home textile, furniture, or, for example, signs do not have a long life. The signs are replaced every 2, 3 years. So it could not be worth to expend too much money registering a single design. But if that is not our case, I mean, if our industries are different, to mention, if we are not in this, registering patents before participating in trade fairs is a good advice. Overall, in those countries where extra registral protection is recognized. In the case of Brazil, there is a grace period for goods exhibited in trade fairs. And we can see that for patents, the grace period is 12 months, and for designs is 6 months. Throughout this talk, we will provide complementary nuances to this information. Mm, If we talk about trademarks instead of designs of patents, it is important to take the precaution to search if our name is registered by another company in the host in the host country. In the case to have a lawsuit, in that case we risk to have a lawsuit, or we risk that direct competitors benefit of prestige. In case we discover a name or another similar is registered by another company in the country that hosts the trade fairs, will have to use a new and compatible name in that country. With respect to legal instruments that law provide, I must recall that Europe and in America as well, the judicial system is under the rule of law, and in the procedure. I will further into the procedural law because it of other talks in this. I'm going to make a stop in a particular instrument that the procedural law and that is especially in trade fairs. I am referring to injunctions. The have been particularly complicated situations where damage can be reversible, the infringement can remain punished. First of those particular cases due to the show very sanctions are efficient, legal instruments first. I think that they are, but better than making this question, we should be pragmatic and ask what can we do to make an efficient use of the legal instruments to combat counterfeiting. And that is what we will try to respond in the following points. So rather than asking if the legal instruments are or not efficient to combat piracy and trade fairs, we must ask how can the agents who take part in a trade fair make an efficient use of these instruments. And of course, we have to ask who are these agents? The first agent are, without doubt, trade fair organizers. And the point of depart for an efficient use of legal instruments to combat piracy is to get a deep knowledge about what trade fairs means. Obviously, um, we take for granted that trade fairs organizers have a deep knowledge of trade fairs, but a deep knowledge of trade fairs means many things. And the first thing that an organizer should know is the real meaning that trade fairs have for exhibitors. As we had introduction, are commercial tools, strategic value since cannot afford to have their own means and first buy their offer and provide them with information about the industry overall if we talk about export or companies. We should also know that in many cases trade fairs represent over the 75% of the annual turnover for exhibitors. So organizers should know that trade fairs can be considered as vital for SMEs. Immediately, we have to note that trade fairs are not sealed and armored places to reality, are not a stranger to copies. On the contrary, trade fairs are fertile and breed soil for copies, since trade fairs are real platforms for innovation. And then there is a high concentration of public interested on it, and of course counterfeiters as well. Very frequently we can see that the original design and the illegitimate copy are disclosed at the same time in a trade fair. And also frequently holders of IPR titles who ignored that his designs were being copied by other competitors realizes that that fact in it is unpleasant to make such a discovery, but the positive thing trade also that information to IPR holders consequence can react thanks to trade fairs. On the other hand, we want to sell our goods. And first to sell our disclose, we can out the risk making a mistake. Trade are much places to disclose goods any other tool. And why can we say that? That's because organizers trade fair are really aware about the phenomenon of piracy. Consider piracy among the most serious witness exhibition industry, as it is, of course, for any other mean tool to disseminate information. And of course, it is a big concern since it has caused companies renowned to exhibit their very last. First, not with fight, see they are their clients and at the to increase quality of the event, the quality and the safety of the exhibition event. Still, we have to add most are public or semi-public corporations. Nationals and local governments are their stakeholders. And since they have a commitment with the general and public, their involvement in the fight in the, to piracy deeper. But we have to ask the position of organizers of trade fair with respect counterfeit. In first place, something that many exhibitors ignore is that organizers lack the authority to determine when we face an infringement of law, and also undertake certain actions. Organizers cannot judge activity, can the activity of justice. Only the Court of Justice can interpret certain documents. If the organizer did it, it would risk to breach the law and also that not always understand, as well as the fact that two or more IPR titles can coexist. On the other hand, organizers have to deal with a tough and complicated enemy, the technological progress. Technology now is not the same that used to be 20 or even 15 years ago, when the simple prohibition to take pictures in exhibition center venue or the surveillance of the premises were quite efficient means to prevent certain kinds of infringements. Today, with built-in photo cameras and other more sophisticated devices, formal measures look rudimentary, even loose. But in spite of that, or better said, because of that, organizers are extremely motivated toward the problem of copies and work actively within their associations to fight piracy and counterfeit. In that regard, we must mention the European Major Exhibition Centers Association, active trade association, that represents two among the big important trade fair organizers has revealed that combating the counterfeit phenomenon in the trade fairs is of vital importance and has also developed a lobbying activity around the legislative bodies in the European Union in order to get more clear provisions. In that task, EMECA collaborates with UFI, the Global Association for the Industry. And in South America, we can mention AFIDA, that represents trade fairs organizers in the region. Naming EMECA is also important. Many of its members are trade fairs organizers in Brazil. Trade organizers within their associations measures to the phenomenon of IP piracy. But obviously, organizers lack a magic formula or SIA to definitely counterfeit at trade fairs. This lack of a panacea is, however, replaced by a policy of good practice that organizers have set up within their associations. And this policy of practices is based on pillars: constant and acute awareness and anticipation. Why constant awareness? Awareness or constant monitoring is necessary because trade fairs last a short time, 3 or 4 days. Then, if we focus ours against a policy just on this day, we will fail for sure. We also take into account that trade fairs are cyclic. Those in themselves, every certain are repeated with a frequency of 6 months or a year. So the surveillance must last throughout the entire organization period. I would like that the fight to fate not only the one age first organizers, it is also job exhibitors. If a job that only taken collectively and a that undertaken collectively and coordinately succeed. Organizers transfer their concern to exhibitors. A good practices police refuse to report the phenomenon of organizers must alert exhibitors about it. How does this good practice policy materialize? With constant and frequent proactive information. Organizers that apply good practices have a detailed calendar of newsletters, mailings, and It's a very complex world. Although the staff of an organizer prepares the event along, along a whole year, the crucial moment lasts scarcely 3 days. These 3 days are frenetic for exhibitors and also for the people who participate in the organization. They have to resolve thousands of incidents and provide thousands of services that cannot wait. They are expected uh, to be delivered and to be solved in question of hours, if not of minutes. They live then a real peak of workload, and the staff is overworked. So although the will of the organizer is all the request, it is not always. A recommendation is not to reduce their contacts with the legal trade fairs just to the time when they create a stronger professional with them, with the legal departments of the legal department of trade fairs of your local area throughout the year. In the case that until now have never been involved in a case in trade fairs, it can happen tomorrow. So it is important to start building the network with the people of trade fairs in your since tomorrow, because the human factor is very important in this critical. If during trade fairs we need to implement a legal action, we have to fulfill legal formalities because fortunately our judicial space in Europe and in America is under the rule of law and do not make decisions arbitrarily but based on legal certainties. It means that we must convince the judge to adopt the preliminary injunctions that we request. And to succeed in the legal action, the company that is going to participate in a trade fair should take the following precautions. First, to have available a power of attorney to represent the company, a power of attorney that is sufficient. I mean that is enough to develop this role has been posted to the fair. Without that, we can have problems to start a legal action. Second, we should have available the documents on which we base our right to request the legal action, the registered title. In the case of Brazil, other documents will not be useful because extra-registral protection is not recognized. And then, in third place, we have to have available any document, photo, catalogs, advertising material, etc., that can help the judge to verify the veracity of the reported infringement. Depending on the moment uh, the moment in which we have realized our request of preliminary injunction to the judge can succeed or not. If it fails, it can be due to a question of time. It can be because of lack of documents. But if it fails, we suggest to request the intervention of a notary, whose job is double in a trade fair. First, to request the infringer to remove the litigious good from the exhibition, and second, to to report, I mean, the second job of the notary is to report the incident by drawing up an official statement with photos of the stand and of the copy. And this statement can be approved in a future judicial proceeding. The infringer exhibitor in the stand and develop his job. In case the exhibitor, the infringer exhibitor refuse the notary entrance in the stand, the notary will reflect his refusal of the refusal of the infringer on his official statement, and it will be piece of evidence. Excuse me. There, there are some organizers that provide this service and replace the job of notaries. And someone of the organization requests in situ the infringer to remove the piece and make a report of the incidents with photos included. This document is, after the fair, handed to both parties to use it as they consider. I have left presentation the subject of the priorities. And I have done it on purpose in order to forgotten these priorities because I consider them very instruments and well, they are not by editors. First, we have the unionist priority. The unionist priority, the source of this priority is the the Paris Union Convention dated on an 83 that was extended the TRIPS agreement in 1990 to the members of the World Trade Organization. The right of priority means that which I register before the intellectual authority, three member of the Union of Paris or the World Trade Organization, and holds a previous IP right on a specific good issued by the IP authority of another country member of the Paris Convention or of the World Trade Organization, entitled to claim the unionist priority for 12 in the case of patents and 6 months for designs and treatments, the date of registration. This priority allows exhibitor who hold an IP title it in Brazil before the trade fairs. They can wait 12 or 6 months, depending on whether we are talking about patents or designs and trademarks, and they can make the decision after the fair. In second place, the exhibition priority certificate or priority for exhibition. The source of this priority certificate or priority for exhibition is as well the Union of Paris Convention dated on 1883. instrument is not always very well known by exhibitors, it is a very effective tool, especially for SMEs, to protect their products and prevent counterfeit at exhibitions. The priority for exhibition means that when a company participates in a trade fair and discloses its goods or designs or patents for 6 will be entitled to register these goods or designs with priority with respect to competitors. As we told in the second point of this talk, the information given about the loss of the number when a good is disclosed in a fair. Sorry, sorry. But to warn that this priority is not automatic during the fair, requested by the exhibitor. This certificate is issued by the trade fair organizer under request of the exhibitor to prove that an item is shown during a certain exhibition. The date of this certificate is generally accepted as registration date by national patent and trade fair offices, and when the exhibitor applies to register a national patent, trademark, or even designs. With that instrument, the exhibitor will have additional cost and can wait until 6 months to decide if the register is needed. Brazil is a member of the Union of Paris Convention since its foundation, so it can be claimed before the Brazilian authority. I mean that the priority for exhibition can be claimed in order to apply the registration of patents or designs or trademarks in Brazil. So priority certificate is a very convenient and often used tool as a facilitator of the registration process for the concerned product, since the date stated on the document can also be used in the event of a conflict. I hope that this talk has been profitable for you, and I also thought that has been helpful for you. And I wait for your questions. Thank you.
Very much, Enrique. Good explanation may have not that of our audience, but maybe you provide some practical example that due to your wide experience in this, you could give us some light in this topic. See if not that we're keeping with this with this. Um, I have you mentioned it in a previous slide. You Yes. I was wondering if this is an efficient tool. A European citizen, I European organizers to use this kind. But I don't know if in Brazil they work too, and if this is the best tool that we can have against piracy, for instance, in that countries. And if it's not the best tool, what do you consider that could be the best one?
Thank you.
Pretty much now it's more clear because if we take into account what you already explained in the related slide, I guess we have a big picture about how this work. Well, if question, and I guess that people became very shy lately, I guess this is all for us. So thank you very much to all the attendees for their which were not so many for being there. Absolutely. Let me know if you have any other query or suggestion. Simply want to have further discussion about this topic. Um, the Mercosur IPR Resume Help Desk is at your entire disposal. There you can find our some contact details, and our helpline, for instance, will provide you with a solution to all your intellectual property needs within 5 working days in English, Spanish, French, German, and even Portuguese. As all our services, this first line assistant platform is totally free, and of course, your data will be treated in strict confidence. You may contact us either by phone, as you can see, email, or through our web form, which can be found in our website. Remember that no question is too little to us. For further information, as I mentioned, please visit us at www.mercosur-ipr-helpdesk.eu. You'll find past and upcoming webinars, clinics, and workshops, information materials such as fact sheets or your IP glossary, videos, links of interest, our signposts in directory, and much more. You can also stay updated to the latest news and events thanks to our newsletter, and we enhance you to follow us in Facebook, Twitter, LinkedIn, and YouTube. In behalf of the Mercosur IPR SME Help Desk, thank you all again. We hope you enjoyed the webinar and hope to see you in the next ones. Goodbye.